YNW Melly appeared in court for motions. Melly's defense attorney once again fails to explain herself properly and ends up withdrawing her motion. Thankfully, it sounds like this trial is not going to get delayed. I'm starting to think Melly made a mistake staying with this lawyer, but it's too late now, bro. This shit's starting in like 2.5 months. Hit subscribe, let's go. State's motion to reconsider oral order moving forward with trial date of September 10th. No surprise here, they're trying to push the trial back. Let's see why. Court entered an order granting motions to suppress evidence December 23rd. That's the shit that went on appeal. State filed its notice of appeal to January 2024. A stay on the proceedings January 26. February 13, 24, the state files motion to pretrial determination of admissibility of evidence. The court also excluded the same evidence. February 14th, the state filed a motion to stay proceedings. Motion was granted. On June 13th, 2025, during an off-the-record discussion of pending motions that needed to be scheduled, the court advised the parties that it intended to proceed with the trial date scheduled for September 10th. The state advised the court that the matter was stayed pursuant to court order and statute. The defense asserted that the motion to stay has been denied, but this is incorrect. The court responded that it had received no such order staying proceedings from 4th DCA. Oh, so they're saying from the appeals court, this whole shit stayed. The appeals court wants to stay it. Oh my God, this is a disaster. The court is without jurisdiction to proceed to trial. They're saying you have to stop. They're telling the judge this. We can't do this trial on September 10th. This court has previously incorrectly ruled in this matter. A trial court is divested of jurisdiction upon notice of an appeal except with regard to those matters which do not interfere with the power and authority of the appellate court or with the rights of a party to appeal, which are under consideration by the appellate court. Similarly, a defendant cannot file a motion to vacate judgment while on appeal from his conviction. They're citing some cases here. The court notes that any litigation what would have impact on the appeal cannot be litigated without leave of court. This case is now stayed by operation of statute, blah, blah, blah. The state may appeal from a pretrial order dismissing a search warrant. Based on this case law and statutes, state contends this court may not proceed to trial. I mean, this shit is just fucking ridiculous. Does the state not want this to go on? I mean, I understand what they're saying, but at every waking moment, it seems like they're just trying to delay it, which I don't understand. It's been so long. Just get it fucking over with. Now into the court footage from last Friday.
Looking at chapter 119, on his face, they should have never been given anything outside of the pleadings, which they could have got from the court. But the evidence, there's no justification for it. Judge, and there's no justification for John Phillips then taking that evidence and publishing it on his Twitter account.
Oh, so this is dealing with the civil case where the lawyer John Phillips posted an autopsy picture of Juvie's face with the bullet hole in his cheek. Apparently he wasn't supposed to have any of this. Don't know if that's true or not. I think they're getting into that.
I would ask that I need Mr. Phillips
Judge is like, what do you want me to do?
basically testify. So it's, I could proffer what's in this letter. I think we need
She wants Mr. Phillips to testify, the lawyer?
Mr. Phillips here to tell us who exactly in the state attorney's office did he make this agreement with, because that's unclear. And I think we need to clearly know what steps the state attorney took in making sure that the evidence was not released, and what steps the state attorney took in deciding what was going to be provided to them, specifically under Chapter 119, because I believe we have a violation here.
Listen, I'm going to hear what Mr. Klinger has to say, but
She's saying the state violated and broke a rule, sending this autopsy stuff to John Phillips.
say I agree. Why should this be in front of Judge Davis? The order in this case that you're alleging is violative of the rule.
Because it's this case that the state attorney is part of. It's this case that we have
Well, I'm
the
going to talk to
Sixth
the state
Amendment
attorney, but
interest.
how do I get to Mr. Phillips? He's not part of it. You're talking to me about he violated an order in CAC 20-17725. I'm not saying whether he did or whether he didn't, but let's say he did. That's in the purview of Judge Davis, right?
So judge is saying this ain't my order. This has to do with Judge Davis, not me. The judge on the civil case.
My co-counsel is reminding me that at hearing, we thought you had directed the state attorney to have Mr. Phillips here, and it was agreed that he would be here.
I asked if anyone put him on notice, but you're asking for a rule to show cause. It's no different than if a witness fails to appear at a deposition. You have to subpoena. That's why over there in front of Judge Davis is different than over here. But you're talking about a violation of a rule that was signed, an order that's signed in the civil case. But, all right, pause on that. Go ahead, Mr. Klinger. Your response.
All right, Mr. Klinger is going to respond.
You don't represent Mr. Phillips, but only as it relates to the state attorney. Yes, sir. Go ahead.
If you're new to the channel, please hit subscribe. I appreciate the support. Back to the video, boys.
Good morning, sir. First of all, to answer the question that Ben's got proposed, I am the one who negotiated with the two civil attorneys on how to handle their little ominous request for public records. Now, at the top of page 3 of my response is a litany of Florida statutes and case law, and they basically stand for the fact that once discovery is given out in a case, that discovery becomes a public record subject to exemptions and redactions. So, in other words, in the statute, actually, to the effect of paperwork given to the defendant, papers given to the defendant are public record.
This is kind of bullshit. He's saying everything's public record that is given over to defense, which is just not true. I've never seen a state attorney argue that. State attorneys do not want evidence public everywhere. That's a fucking lie.
The state being faced with a huge amount of discovery that the defense needed because the trials that had been set earlier this year, I believe one was set, first it was set this summer, then it was set for last winter, and they needed their discovery, or they needed at least the public records from the state. We were honest with them. We said it would take a very long time because there's thousands, if not hundreds of thousands of pages of discovery, especially with the phone calls that actually we needed. So following a procedure that we used in State versus Nicholas Cruz and State versus Scott Peterson, two other cases in this courthouse that had enormous amounts of discovery, we negotiated with the civil attorneys that they would be able to get the discovery unredacted, but it would have to be under protective order. How we have, it's not going out to the public. It stays within the people working with the attorneys' firms, the families of those families, and the people in the courtroom. That it had to be protected, just as it was in Peterson and as it was in Cruz. And that was the gist of our. So I think at that point, what happens next with the agreement, how it gets handled, how it's come to why Judge Rodriguez later on signs an order saying that the defense motion to strike the original order from former Judge Lynch are all questions of the civil court and probably a potential hearing of the civil court to see whether or not the orders were violated. When it comes to this court and you're looking at the state attorney's office, the state attorney's office did absolutely nothing to put anything out to the public. They were supposed to be on the streets.
Okay, so the state attorney's like, we gave it all to John Phillips. He's just the idiot that tweeted it out. A civil attorney tweeting out autopsy pictures. I mean, that's batshit crazy to me. I know he probably had permission. I think he said that, but come on, bro.
Autopsy photographs are special, and so when you look at the entire package that comes from the MD's office, that never went out. It didn't go out.
Here's first look at Melly. I don't know why this stream started late or whatever. We didn't see him walk in, but apparently he walked in pissed off, like not happy, and like sat down all quick. I don't know where that clip is. And his mom, Melly's mom, said he's mad at his attorneys. That's why she said he did that, but I don't think she really knows because she can't talk to him, but I don't know.
It did go out in discovery to the defense, but it did not go out to the public record, and it did not go out underneath that protected rule. Although I can't say with 100% certainty, again, something maybe in the civil court Mr. Phillips will have to address. There is a investigative report inside the discovery of this case that was done by the Radley Export, lead detective wide, wherein they put together a recreation of the crime scene and how the bullets were shot, who had to be where in order for the bullets to go in the direction, or if they hit from whatever direction. And it appears that some of those autopsy reports made it into that particular document. And that was under the protective order. So, again, I think that is why this is better off being heard in the civil court. And
so this is the response I expected for this. He's saying this is a civil issue with the other judge and everything, not here.
Out as to why that on the witness, why it was on him. I don't see how the state should be held, Mr. Breyer or the office or myself should be held accountable for something that we did everything we could to prevent from happening.
May I respond? So what I was looking for under Chapter 119, and thanks Mr. Klinger for letting me know.
The longer this goes on, the more I think Raven Liberty is not qualified. It's too late, but he should have got a new lawyer, a lead attorney. I'm sorry.
I'm going to call Mr. Klinger at the next hearing when Mr. Phillips is here. If they authored this agreement, and his argument is that we had to turn this over pursuant to 119. So again, going to 119, it's under here, I believe it's subsection 5 D goes on to talk about what active is. So you go to the subsection of 2, criminal investigation information shall be considered active as long as related to an ongoing investigation, which is continuing with a reasonable good faith anticipation of securing an arrest or prosecution in the foreseeable future. In addition, criminal intelligence and criminal investigative information shall be considered active while such information is directly related to pending prosecution or appeals. That's the entire file that the state attorney has that wasn't published, it was protected, it was exempt. But under here, they prepare an order saying Chapter 119, this is what we're going by, but then they violate what Chapter 119 says is exempt. And why it's here? Because it is the state attorney's office. Why it's here? Because we are dealing with a death penalty case. So there should be these
The judge's face, sometimes you look at his face right now. He don't give a shit about any of this.
protections to things like the Sixth Amendment, the right to a fair trial. You didn't have to sit through the jury selection, Judge. That's what you haven't had to deal with in this case. And one of our biggest problems in this case is people knowing who he is. We have sat through hundreds of jurors, and they've read something, they've seen something on the news, or they've heard his music, and we're just going through them. So to be sitting here on a retrial, faced with the fact that there was so much media attention to the first trial, but now I have a civil attorney taking further steps just to publish evidence and argue with people about it.
It's very immature. A civil attorney should not be doing that. Like, bro's legit picking fights on Twitter as an attorney.
A fair trial is what I'm asking for my client, and that's what I'm asking for in this courtroom, because you do have jurisdiction over the state attorney. A civil judge doesn't. Jurisdiction over the state attorney. Mr. Klinger just admitted he was the attorney that wrote up this agreement and negotiated with them. So, yeah, we need to question Mr. Klinger why he turns this over in light of 119 saying, well, there's a pending trial, everything's exempt.
So what relief are you seeking against the state?
I would ask for the same rule to show cause of why they're not in contempt of Chapter 119 and in contempt of the United States Constitution and my rights. My client's right to a fair and impartial trial.
Consider there's 2 ways I get to hold someone in contempt. 3.830, that's direct criminal contempt. That has to happen in my presence. That has to happen. And 3.840, indirect criminal. No one asked me for an order for anything. Has anyone sought an order in the criminal case saying we don't want any of this released? Period. We want you to enforce 119, and we got a civil judge who's entering orders that shouldn't be ordering, and judge, we want you to shut it down. Can anybody do that?
We have notice of this. So you're asking me something, did I do something?
How does that have notice? It says Jamel Demons is a defendant in this case. Who's involved?
The civil attorney didn't get notice of it. That is what I attached, and I could
So
not.
if something's happening in a civil case, rules are being broken in a civil case, if an order that a circuit judge, or now it's Judge Davis, okay, Division 14, in a civil case, you have to go to that judge for all of the reasons. If someone hasn't complied with the orders, and if what you're telling me is true, I don't have any evidence in front of me today, I don't have anything about what was or what wasn't posted on social media, I'm sure you're telling me the truth, but there's no evidence of record in my case of that, but if what you're proposing is true, it could very well be a violation of this order that was entered on,
Because I'm not saying they violated that order.
well, the order says that this is all confidential except for the 9 parties listed in the order, and social media is not one of the 9 parties, so sounds to me like it is, but you gotta go see Judge Davis about that. I didn't order.
Dude, this judge has a reoccurring thing where he's like, this has nothing to do with me. Y'all gotta figure this shit out. Like, this is like the 5th time he's basically said this. And I love his army haircut, dude. Looks like a fucking army general.
If I may, I believe my motion is in order for a rule to show cause against the state attorney and John Phillips. But I was asking for under that rule initially under indirect because I have to ask the court for it. Which would then, I would then get the order under that rule laying out the different things, and then I would have to serve it on both Mr. Phillips and
So
Mr.
you're telling me what you're alleging they violated is the Constitution and the bar rules?
2 bar rules, Judge, in the publication, but that's with Mr. Phillips. All right, that's
What are
right.
you saying to the state attorney?
The state attorney, the simple agreeing.
You serve a witness for a death vote. They don't come to the death vote. You come and say, Judge, I want an order to show cause. Tell the person come to the court and tell me, why didn't you answer the subpoena? Why didn't you come to court? So what is it that you want the order to show cause?
I want
to
an
say
order
to the state?
to show cause against the state of why they negotiated an agreement in violation of Chapter 119, turning over confidential information. And
Okay, I'm sorry. Raven Liberty sounds dumb sometimes, bro. Why isn't she more prepared on what exactly she wants? She doesn't sound confident. She's stumbling on her words, stuttering. Like, she just never seems prepared. It always seems like she's flustered.
this file while a death penalty trial was pending.
That's what they're saying.
But then he's going to say he doesn't have jurisdiction over the state attorney.
Listen, I'm not going to speak for another circuit judge.
Look at Aldestein coming up like, yo, you need to say this. You're fucking up. You're not doing your job right. Another lawyer coming up to tell her.
You're asking me to conduct a contempt hearing based on a violation of an order that another circuit judge entered. So you got to go talk to that circuit judge. And as far as a violation of the bar rules, that's not incumbent on me to investigate or anyone else. Anybody can file a bar complaint. If you all think that the state attorney's office has violated the bar rules, we'll file a bar complaint. You can do that today.
We take a 5-minute recess.
Sure.
Stewart's like, we need 5 minutes to come up with a plan because we're completely shit in the bed right now. That's what's happening. Oh, this is the clip. Look, he's pissed. Look how mad he is.
In light of what Mr.
Bro is pissed. Not having a good time.
Klinger proffered outside, I would withdraw, I guess, a contempt against the state. On my rule to show cause against the state, I would move to continue this hearing so that we could do two things: depose Mr. Phillips and subpoena him for the hearing. I never coming back, I believe, July 9th. The court could put time there or give another date just to continue this.
Well, Mr. Klinger, I presume you have no objection to the withdrawal of the question that's related to the state. Is there any position that the other comes together?
As was cited in my response, I would
This is what I'm going to do. Okay, and again, first, and I appreciate the parties talking it over, and I appreciate the questions as well. Based on the agreement of the parties, I'll make a written order today. The defense is withdrawn. Motion for order to show cause as relates to the state attorney bail that's Friday. First, I'm going to two separate orders. I'm going to order after that. They're withdrawing the motion for order to show.
So this was pointless. They're withdrawing now after what they figured out over break. Okay, cool.
The office for our state attorney bail that's Friday. As to the pending motion against John Phillips, respectfully, I'm going to deny it without prejudice for you to address it in front of Judge Davis. The allegations are a violation of the confidentiality/protective order that was entered in that case. The attorney is representing one of the parties in that case. If the allegations turn out to be true, it certainly could be a violation of that court order, whether or not that rises to the level of contempt, whether or not that rises to the level of violation of the rules regulating the court of law. That's going to be Judge Davis' decision. If someone wants me to enter some type of protective order with regards to the criminal case, I can only file a written motion requesting whatever it is they want to request. I can hear that the next time we're all together, which is July 9th. That's the defense motion for rehearing as to my ruling, as to the renewed motion for bond, as well as the pending defense motion for order to show cause regarding the law enforcement officers calling into question the deposition and whatever other matter here. Mr. Devins will remain set for trial September 10th.
Set for trial September 10th. So it sounds like he's not delaying this trial. The state filed that motion to delay the trial. He ain't doing that shit. Just like I said. This man looks so over this shit.
If you do it at 9:30 in the morning, I'll give you the whole day if you want, but if you
Not a good day for Melly's team in court, but thankfully it sounds like he's going to deny the state's motion to delay the trial. So yeah, hit subscribe. Love you guys. Peace out.